them and send them. Right. So welcome again to the AIPPI panel on fair use, which is organized by AIPPI Canada. I will briefly introduce our panelists. I'm Brian Gray, a barrister and solicitor in Toronto. And we have with us today Daan Erikson as a senior associate at Husch Blackwell and a self-described copyright nerd. We also have Professor Jane Ginsburg, professor of law at Columbia Law School, a well-known expert in copyright law, and another well-known Canadian expert in copyright law, Ysolde Gendreau, professor at the Faculty of Law at the University of Montreal. So this is a Canadian-sponsored event, as I said, and we in Canada have a love-hate relationship with the US, which is a dynamic society. And nowhere is that dynamism more evident than in the creation of new copyrighted works. However, maybe in their zeal to allow the use and reuse and appropriation of such works, maybe they've gone too far and failed to protect the legitimate rights of copyright owners. So that is really one of the things we will be discussing today with respect to the fair use defense. So first up will be Dan, who will tell us about how fair use has fared since the Supreme Court decision in Google and Oracle. And then secondly, we will have Professor Ginsburg will describe the holding in Goldsmith and the Warhol case and put it in the context of previous appropriation art cases. And finally, Professor Gendreau will give a Canadian perspective on the Warhol case and how that appropriation art might play out in Canada. And again, in order to give time for questions, I will limit the panelists virtually initially to 10 minutes each, and I will be signaling that as we go along. So I'm putting my little stopwatch on right now, Daan. And so right now, you have 10 minutes.
Very good. Okay, so we are going to share my screen here so you can see my slides. We're going to go to presentation mode. That's the one. Okay. Hi, everybody. Daan Erikson here in Boston with the law firm Husch Blackwell. Happy to.
Daan, can you take off your notes? Remember, you have the.
Are you seeing the wrong screen? Okay.
We're not seeing the whole screen. We're seeing your notes as well.
That better.
Right. Yeah, perfect.
Okay, great. Thanks. So yeah, thanks again, Brian, for inviting me. Very happy to be speaking to an international audience at AIPPI here. So I'll be talking about last year's Supreme Court decision, Google versus Oracle, and the lower court interpretations that have come out since then, interpreting this new guidance that the Supreme Court gave on fair use. First decision in a couple of decades, about a couple of decades, dealing with analyzing the fair use factors. And so just in case you need a little refresh on what those fair use factors are under US copyright law anyway, here they are. The purpose and character of the use is the first factor. The nature of the copyrighted work is typically considered a little bit less. The second factor, the third factor, again, not considered typically the most important factor, but that being the amount and substantiality of the portion used. And the fourth factor, which like the first factor is typically considered more important, and that's the effect of the use on the potential market for or the value of the work. Now, to some of us US practitioners, the Google versus Oracle decision by Justice Breyer was unusual for a number of reasons, including these I've listed here, that he began the analysis, he writing for the majority, began the analysis with factor 2, so looking at those factors out of order in the analysis. Another unusual point was that the majority discussed transformativeness in a different environment for new products, expanding the use and usefulness. And when I saw this factor, it really struck me, is this going to be software specific, like dealing with the APIs in Google versus Oracle, or could this really have a big impact for clients like the ones that I advise and have to give guidance on? What might a court do in determining if something is fair use or not? Because that has evolved over time with the way that different courts have dealt with this, but this is really seeming to be a new approach. The third point that I would note from Google versus Oracle is that the majority of the Supreme Court analyzed how much of the original work was not copied. And that's not part of the statutory language of the test. And typically courts who do that kind of thing get overturned. But it was a point that the Supreme Court made in Google versus Oracle. And finally, rather than evaluating the potential, the effect on the potential market, they reviewed the market effect. And again, we can question whether this is going to be a software specific consideration, or if this is something that courts going forward will have to deal with. And I will leave more of that analysis to Professor Ginsburg looking at the Warhol case. But looking at the cases that have interpreted Google versus Oracle, when I gave this presentation or a version of it at the Fordham AIPPI conference in April, there were 10 cases that had cited Google versus Oracle and analyzed all of the 4 fair use factors. There have been other cases citing Google versus Oracle, but not going through that 4-factor analysis. Since that talk, there have been 2 additional cases that have been decided with opinions issued. So in looking at those 4 points that I laid out of things that I found unusual in the Google versus Oracle opinion, I reviewed those 12 cases for those points. And you can see in the chart that's laid out here, my presentation could be about 5 seconds of no, lower courts are not doing this. But basically, to go through it in a bit more detail, none of these cases involved software. None of the 12 cases that went through the 4-factor analysis involved software. And so none of them, as you see here in the chart, none of them started the fair use analysis with the 2nd factor. They all analyzed the 4 fair use factors in order 1, 2, 3, 4. All of the, and I can flip to the next slide so that you can see that's also the case of the last 2 cases that came out since April. And as for whether these courts and judges had looked at the transformative factor, which is the having to do with the 1st factor, on looking at, as they did in Google versus Oracle, whether the case involved new use in a new environment for new products to expand the use and usefulness, the answer there is also largely no. Courts were not looking at that. They do still look at transformativeness in general, but not this idea of, well, this use, like, in Google versus Oracle, was for one thing, computers and laptops and whatnot, and now it's being used in mobile phones. It wasn't about, there was no evaluation of looking at new products. And then in the 3rd point, looking at how much was not copied, that generally was not the case, except in a couple of cases it was sort of mentioned a little bit, but it was not used as the determinative test under that 3rd factor, looking at the amount and substantiality of the use. On the 4th effect, nobody is looking at the market effect versus the potential market effect. They're all considering the effect on the potential market using the original language. And as you can see here, these different cases came out with varied rulings, sometimes fair use, sometimes not fair use, sometimes factual dispute exists. So different. Yeah.
You have three minutes, Daan.
Thank you. So yes, different outcomes in the cases, even though they followed generally the old way of doing things and not the Google versus Oracle outline of things. So that's been, I would say, to practitioners, perhaps a relief in terms of Google versus Oracle not turning everything on its head. But at the same time, I have a friend who's a software developer who was very excited about the Google versus Oracle decision and saying, yeah, no, we should be able to make new products using this. So it sort of depends on your perspective. But I would note that there is an additional case citing Google versus Oracle that's worth mentioning because it does deal with software, but it did not involve analysis of the 4 fair use factors. So it did not fall in the 12 cases that I analyzed there in the chart. And what's interesting about this is this court in the Northern District of Illinois was referencing that Google is important with regard to this, but they didn't have to analyze it because of the particular facts involved in the case there. So, but it said at the very least, Google refined and clarified that copyright fair use doctrine with respect to computer programs and copying computer code. So lower courts may be recognizing the narrowness of that ruling, but hey, perhaps we will see more with the Warhol case once the Supreme Court has issued its opinion there, if they explicitly clarify or not. I'll leave that to Professor Ginsburg to conjecture, but with that, I can leave it there and happily answer any questions that you have.
Thank you, Daan. You're 1 minute early, and that's great. So we'll have time for questions later. So now we'll hear from Professor Ginsburg, who is going to tell us about the Goldsmith and Warhol case and put it in the context of prior cases. And it's that. Professor Ginsburg, I'll wait for you to get your slides up.
Okay.
They're not quite, there they are. Okay.
I guess I should do slideshow from beginning. Okay.
Yes, from beginning. Yep.
Okay.
Yeah, you can.
All right.
I'll
Ready?
start now. Yep. Start
Okay.
for 10 minutes.
So thank you, Brian, very much for inviting me to participate in this discussion with a very interesting comparative law dimension. I'm looking forward to Professor Gendreau's discussion. And I've been asked to talk about the pending Warhol decision. There's obviously more than 10 minutes worth of discussion. I will try to limit this to the focus of creating new works of art based on prior works. Since Daan already put up the factors, I will go straight to some of the case law. So, there's been a lot of talk about transformative use and what transformative use means. I will address that as well, but I want to start with a case that was decided before the Supreme Court adopted the nomenclature of transformative use in the Campbell and Acuff-Rose case. And this is an early appropriation art case. The Koons is the well-known, not to say notorious, Jeff Koons, who appropriated this black and white photograph by a photographer named Art Rogers, sent it to some artisans in Italy and said, I want you to make a sculpture as much like the original as possible. And Rogers subsequently sued when he learned about this from somebody who thought that he had authorized a 3D color version of his image. Jeff Koons' defense was fair use, that this is a parody. The problem, particularly for the Second Circuit, is that it wasn't really a parody of Art Rogers' photograph. It was a acerbic commentary on the American suburban lifestyle captured in the photograph. And the Second Circuit was rather skeptical of this, that you can't say that this is a parody if Rogers' photograph, which was fairly obscure, wasn't known to the public. It's one would presume that the public would get the reference, and there was no reference to get in this case. The Second Circuit was also not so impressed with the argument that Koons was actually satirizing something about the broader society the rejoinder on that was, well, you didn't need to take Art Rogers' work in order to achieve that objective. So even though Art Rogers and Jeff Koons operated at very different ends of the art market, the Second Circuit considered that this was not a fair use parody, and that Koons had usurped Rogers' derivative work right to make 3D versions or color versions. Fast forward to only 2 years to the Campbell case, in which the Supreme Court adopted Judge Laval's nomenclature of transformative use, in which the creator of a work based on a prior work gives the work new meaning or message. And transformative use has expanded a lot under the rubric of giving the appropriated work new meaning or message. But one should go back to the Campbell case in considering later cases, notably Warhol, to remember that the Supreme Court did not say, if transformative, then fair use. The Supreme Court, in fact, in that case involving a parody of the Roy Orbison's song, Pretty Woman, by the rap group Two Live Crew, sent it back to the lower courts to determine whether, notwithstanding the fact that this is a parody, whether it took too much. So was it a third factor, more than was needed for the transformative purpose? And implicitly, did the Two Live Crew version, if it were to be considered a rap version rather than just a parody, then it would conflict with the fourth factor in that it would have a deleterious effect on an actual potential market for the work, that is licensing a musical work for other genres. Now, since the Campbell case and the adoption of transformative use by the Supreme Court, transformative use then has a heyday in the lower courts, notably in the Second Circuit. So here we're back to our friend Jeff Koons, who has taken the photograph, the commercial photograph of Andrea Blanche, and has collaged it into this larger work called Niagara. And Jeff Koons had a detailed explanation of what role that image was playing in the larger agenda of the photograph, and the Second Circuit agreed that this was fair use. The so-called high watermark, or some would say low watermark, of transformative fair use in the Second Circuit is this case involving a photographer, Patrick Cariou, who took images of Rastafarians. His works were then adopted, enlarged, and retreated to a greater or lesser extent by Richard Prince in a series called Canal Zone. As you can see, some of the images, here's the Cariou here, were very much redone. Some would say that the Cariou images presented the Rastafarians as a sort of noble savage mode, and the Richard Prince retreatments were anything but. The Second Circuit held that Prince's retreatments were transformative as a matter of law, except for 5. We'll get back to that, including this image was not transformative as a matter of law. Most controversially, perhaps, that the market for Cariou's work was not deleteriously affected by Prince because Cariou's book was out of print. Prince sells his canvases for millions of dollars at very high-end galleries. The audiences for the works are completely different, and Prince does not substitute for Cariou's audience. That attracted a fair amount of criticism. The idea that that Prince's market was a, quote, transformative market because it was so different from Cariou's market. And this case also, I think, was probably the best example of what Barton Beebe has called stampeding. That is, if a court finds that the use is transformative, then all the other considerations just fall into line to support the ultimate conclusion that the use is a fair use. However, the tide then starts to recede. In this case, still Richard Prince, another Rastafarian. Here, the Southern District rejected the argument that this is fair use as a matter of law. The district judge compared what Prince had done in this case with the 5 photographs that were not fair use as a matter of law, including this one, and concluded that the treatment of the Rastafarian photograph in this picture simply was did not transform it in any meaningful way, and therefore denied summary judgment in this case. So even before we get to Warhol, we might be able to synthesize some of the cases on how transformative is the use based on whether the appropriator has taken a single image or multiple, or has taken that image and put it together with multiple images, and how much intervention in the actual image has the defendant done. This
Okay,
brings
sorry,
us to,
you have 2 minutes.
okay, so this brings us to Warhol. This is the Lynn Goldsmith original, which Andy Warholized, and I'll skip over the district court opinion. The Second Circuit holds that it's not all that transformative because the Goldsmith original remains fully recognizable beneath the Warholization. It's a single image, so it hasn't been collaged with other images. And perhaps most importantly, the finding of transformativeness was not determinative. Rather, the Second Circuit paid a lot of attention to the 4th factor, that is the effect of the use on the market for the work. And in that respect, one could say that Warhol should be an easy case because the Warhol image was in fact licensed by Goldsmith. The practice of using photographers' work as a so-called artist reference, here is an example, is quite widespread in notably the magazine world. That Warhol image appeared in Vanity Fair magazine. When it first ran in Vanity Fair magazine, Lynn Goldsmith was credited for being the source image, and she was paid. The second time around, when Vanity Fair reran the image after Prince's death, she was not credited and she wasn't paid. The case should be an easy case because we don't even have to think about whether there is a prospective market for artist references. There's an actual market for artist reference, which a claim of transformative use taken on its own without being balanced against the market for the reuse of images for artistic treatment would lead to very different result. It would take us back to Prince and Cariou if transformative, then fair use. But the Second Circuit has made pretty clear that it has turned away from Prince and Cariou and is putting a lot more emphasis on the 4th factor. So I think I'm out of time, and I trust that we'll have discussion time afterward.
Yes, you are out of time, but I appreciate you're close. So I think we're still moving along pretty well. So Professor Gendreau will now give us a perspective on Canadian fair dealing in the context of the Warhol case.
Very well, thank you. Thank you very much, Brian, and thank you to you and to AIPPI for asking me to present this Canadian perspective on the Warhol case. In Canada, of course, we do not have fair use. We have fair dealing. And I don't understand why my PowerPoint is not moving. I'm sorry. I think I might try with a different share. I'll do that. Here, this should move. Yes. Okay. So Canada does not have fair use. It has fair dealing. And fair dealing in Canada is present in 3 provisions. The most important one for us is the first one, Section 29, which includes 5 purposes for fair dealing. You will notice that parody and satire, as well as education, are placed in this group of purposes for fair dealing. And together with education, they are purposes that were added in 2012. If we compare that with the other provisions on fair dealing, like the following one that deals with criticism or review, we see that conditions are added in order to have valid exceptions. So it's true for criticism and review, and it's also true for the purpose of news reporting. Therefore, it becomes important for many users of works to rely on fair dealing from the first group of fair dealing purposes that are identified by the law. You will also have noticed that the fair dealing provisions do not have the language such as these purposes, and therefore it means that it's a closed list of purposes as opposed to the fair use purpose in the US. Another distinction from the US system is that we do not have in our statute the 4 criteria that have been mentioned by our 2 previous panelists. So it's been up to the Supreme Court to create criteria to analyze the fairness of the dealing. And it has created 6 factors to help us with this exercise: the purpose of the dealing, the character of the dealing, the amount of the dealing, the alternatives to the dealing, the nature of the work, and the effect of the dealing on the work. Now, this is the strict wording of the character of the factors as identified by the Supreme Court. And if these factors look familiar, it's because they are indeed very closely inspired by the US factors. There's only the 4th one, alternatives to the dealing, that does not seem to have a counterpart in the US environment. What, however, will characterize our interpretation of fair dealing is that from a general perspective, exceptions in Canada are identified as users' rights. So here the debate is not so much about transformative use as about the idea that an exception is a user right. And since they are not exceptions, they have to be interpreted broadly. Whereas normally when you have exceptions, you think that these exceptions are to be interpreted narrowly. This was decided also in the same case of CCH Canadian in 2004. And this was the first opportunity that the Supreme Court had to interpret this idea of user rights in an exception context, because that user right philosophy was first articulated 2 years earlier in the Theberge case that you have here. So then you wonder, how do you use this exception of fair dealing? What is the process you must go through? First, you have to go and identify the purpose, and that purpose must be given a large and liberal interpretation, always because we have to make sure that this user right is as strong as the economic right that the author or the copyright owner is exercising. And this is going to be the first step. Then the next step will be to analyze the factors and to go through the fairness analysis. And in our most recent Supreme Court decision on the issue of fair dealing last year, the court emphasized that it's very important to analyze the fairness of the dealing from the perspective of the ultimate user of the work. So if we had Warhol in our Canadian courts, what would we do? First, would it come within one of these purposes? And as I mentioned earlier, it's much more interesting to use one of the 5 first principles because you don't have the conditions. And here the debate would be between parody or satire or criticism. And because criticism would have its conditions, would the court consider that the Warhol situation is a parody or a satire? My own personal belief is probably not, given the way that the court has, given the way that it's been expressed as a, the artistic process of Warhol in his case would be more likely to be criticism. But then if we say criticism, we are stuck with the condition, which was respected when the first Warhol drawing was published in the magazine, but which was not respected with the other series of Prince pictures in the Prince series. So does it come within that one of the purposes? If so, then we have to apply the 6 factors. And if we find that none of the purposes apply, then perhaps we might have to look for another exception. But it is quite likely that the court, or at least the Supreme Court, would be able to find a purpose. The Warhol decision also makes mention of the relationship between the exception and the existence of the right to make derivative works as a right which is comprised within the economic rights of the copyright owners. And what I'd like to do here is simply to show you that in our main provision on copyright economic rights, we have, and this is only the first part, but we don't need to go further. We don't have specifically a right to make derivative works. We have the right to reproduce, and we have subsections that provide examples of what these reproductions could be. Only perhaps the last one, the one dealing with making a cinematographic adaptation of a work, do we have something which is perhaps more, which is perhaps closer to the derivative work issue. But then again, our Supreme Court said that these subsections are examples, and we might see that what Warhol did was actually a derivative work under the reproduction right theory. Then, of course, another aspect that I would like to highlight, which was not mentioned in the Warhol case, but which is here in Canada, is the issue of moral rights. And we have here in Canada the moral right of integrity, which refers to modifications by somebody. And in this section, we also have the fact that we need to demonstrate prejudice to the author's honor or reputation. This is fundamental to the exercise of the moral rights. And there's a specific subsection that deems privilege when the modification is done to a painting, a sculpture, or an engraving. But in this Goldsmith and Warhol Foundation case, this is not the case, it's a photograph, so it wouldn't benefit from this deeming provision, and there would have to be an actual demonstration of damage to the author's honor or reputation. So I'd like to end on this note and look forward to your questions, and thank you for your attention.
Ysolde, you were perfectly on time, and I didn't have to remind you, which was my own fault. I was so intrigued, I forgot to remind you, but you were on time, so that's great. And just so the audience knows, I did not impose these 10-minute time lanes arbitrarily. The panelists agreed to it and suggested that, and I, just so you don't think I'm this brutal the timekeeper, that actually that's the end of your time here. So what I would like to do now is we have one question from the audience, but I think hopefully we'll get a few more. Let me turn off my alarm here. So we have one question from the audience, but I'd like to first ask Professor Ginsburg about this tension between, which the Second Circuit really highlights in their decision in the Warhol case, this tension between derivative works and fair use. I mean, if you suggest that it's fair use to create a new product, which at least is suggested in the Oracle case, if it's transforms, if it's a fair use to transform something, how does that square with the derivative rights, which clearly are in the purview of the copyright owner? In fact, as you know, the U.S. Copyright Act specifically says that they have the derivative rights which arise from a transformation. So how do you think that the Supreme Court, or first of all, how does the Second Circuit deal with this tension between derivative rights and fair use, and how do you think the Supreme Court is going to deal with that, or will they?
Okay, well, first of all, you're right to start with the statute, that the exclusive rights under Section 106 include the right to make or authorize derivative works. So it's a much more general category than in the Canadian Copyright Act. And the statute defines a derivative work as lists a bunch of examples and then says any other form in which the work may be recast, transformed, or adapted, which gives rise to some tension. Indeed, the Seventh Circuit has criticized the transformative use nomenclature, saying that's not in the statute and is potentially in tension with the derivative work right. So the Second Circuit in the Warhol case, in its examination of the transformativeness or not of the Warhol image, considered that it wasn't criticism, harking back to what Ysolde said, that Warhol was not saying anything about Goldsmith's presentation of Prince. He may have been saying something about Prince. He may have been wanting to create an iconic image, which he initially did under license, but there was nothing apparent from his image that in any way was a criticism or commentary on Goldsmith's particular treatment of the artist known as once and formerly known as Prince. So that's I think that's very important to try to understand what is meant by a transformative use. Particularly in the case of photographs, simply putting the image in another context, whether it's a medium transformation like the serigraphs that Andy Warhol made, or some of the other cases that were on Daan's slide. Courts distinguish between just taking the photograph to put it in a news story about the event that the photograph documents. So the news story is not about the photograph, it's about the event in the photograph, as opposed to writing a story about the photograph itself. And the Fiorinelli case is an example that where the story is about the photograph, then reproducing the photograph may be fair use. But where the story is about the event, then there's no reason that this particular photograph needs to be used, at least not without paying for it or acquiring a license for it. Now, there's been a lot of pushback about the Second Circuit's approach to transformative use, the suggestion being that the Second Circuit is playing the role of art critic, which it's not supposed to, in trying to ascertain whether Warhol really had anything to say about Goldsmith as opposed to about Prince. And it's true that can be a somewhat delicate path to tread to avoid passing any kind of merit judgment on the alleged transformative use. But on the other hand, I think it's very problematic to say as long as the use gives new meaning or message to the appropriated work, then it's transformative, because then we really would have completely collapse derivative works. Most derivative works give some new meaning or message to what they copy. A film based on a novel is going to give new meaning or message to the novel. A musical arrangement, which is another classic derivative work, may give new meaning or message to the underlying music by changing the context, etc. But that brings us to the Campbell case, where the Supreme Court didn't say this is a musical parody and of story. The Supreme Court sent it back to consider, are we talking about a parody or are we talking about a rap version? Right? That's a derivative work. So I think that it's a little too facile to say, as long as you give it, as long as somebody can see new meaning or message in the defendant's work, then it's transformative. And if it's transformative, then this is the carry you step. If it's transformative, then there's no deleterious market impact, because the market for the transformative work is not a substitutional market. One way out of perhaps of the dilemma is to, even if one acknowledges that the work has been given new meaning or message by being Warholized, is not to stop there, but to consider the market effect. And this is a case where there's very clear market effect because there was a license in the first place. And all that was done was to make the same use, but without a license. And there, that's a pretty clear substitutional effect.
Okay, thank you very much. Do any of the panelists have questions of each other, or if not, I have some other questions? Ysolde, no, at this point? Well, if you think of, Nimmer has said in his book that had Congress legislated a dartboard rather than 4 fair use factors, the upshot would be the same. So I'd like Daan to comment on this, and maybe Professor Ginsburg. Aren't these factors so subjective that it makes an attempt to actually advise people almost impossible? Daan, would you like to comment on that first?
Sure, I can start on that. I have to advise people that have real problems and they want to know if something is fair use or not. And I guess I should say too that my views are my own and not my law firms and not my clients today. So with regard to your question, I mean, yes, you have the 4 fair use factors, but we also have a lot of case law to be able to go off of. The problem with that case law is, as Professor Ginsburg described, there are sort of ebbs and flows of what happens with that. So you have to follow the trends and see what courts are doing with regard to fair use in different types of works and different types of uses. So, unless I talk to clients, unless we have the exact same problem that's already been litigated, there's no guarantee that a judge or jury is going to find that something is fair use, but we can go off of a little bit by analogy, cases that have happened before. And I think that is essentially the same as advising in other areas of law as well with infringement. You're kind of going off of the cases that are there. So it is difficult, but it is an interesting area of law to practice because it is sort of ever changing.
Professor Ginsburg, isn't transformative really the most subjective of subjective things? Is there a way that the test could be made more predictable by using something more objective?
Well, the first factor used to be considered an inquiry into the productiveness of the use. Was the plaintiff's work copied in order to produce a new work? And I suppose that is somewhat more objective than transformative, although of course productive use had an uneven career as well. Judge Laval's article, I think, was certainly getting at something in refining productive use to inquire if there was something that the defendant was saying that the plaintiff wasn't saying and wouldn't say. The Campbell case gets to that in stating that there is, quote, no market for parity. That is not a descriptive statement, it's a normative statement. We don't want the copyright owner to control criticism about the copyrighted work. And so if we think of transformative use as not merely adding new meaning or message, because that's far too broad, but adding a new meaning or message that the plaintiff, that the underlying author wouldn't, or at least that would, a new meaning or message that we don't want the underlying author to control, then maybe we can give a few more guardrails to transformative use.
Okay, thank you. We do have a question about essentially about the three-step test, which of course I think is what most of us, people in Europe and outside of the United States, will ask ourselves: how does the fair use, liberal sort of allowance for fair use, comply with the three-step test? Meaning that does it not result in a conflicting with the normal exploitation of the work, or unreasonably prejudice the legitimate interests of the author? And a question has been asked about that, specifically in respect of Article 17 of the TRIPS agreement. So, Ysolde, would you like to comment on that?
Well, the three-step test is always in the background when we analyze exceptions. So I think it has been generally agreed that the fair use exception in the US is legitimate in light of the three-step test, and that the three-step test does not mandate specifically precise exceptions in the statutes. The exceptions can exist as they are created and evolving through case law. So I think that if there had been some doubt as to the validity of the fair use exception, I think by now it would have come out as a major issue. Perhaps one thing I would like to add, however, to this debate is that in the US, they are very fortunate, well, depending on what's your point of view, in having lots of cases dealing with fair use and lots of cases where you have various applications. And as was mentioned, they have ebb and flow of various criteria and how they are interpreted. This allows really the concept to grow and to have a definition that, yes, will evolve with time, but that can still allow parties to continue to interpret and to look for new understandings of what it means. In the Canadian context, we do not have as many cases before the courts. Even in a proportional sense, access to the courts is not as broad as in the US. And therefore, whenever we have decisions, and especially decisions by our Supreme Court, they do not create this kind of environment where other decisions will continue to build on that. They seem more like oracles on what fair dealing is about than an act in the construction of what fair dealing is about in Canadian law.
Yes, and they also seem to come out often out of collective society cases rather than individual parties. So that, whatever that means. So Professor Gendreau, just one question for you about user rights. So you mentioned user rights. In the context of, say, Google and Oracle, are we talking about the user right of the persons using the Android program? It seems kind of a way that Google avoids liability, and while it makes millions of dollars appropriating some of the software from Oracle or the Java software, by relying on the users who are using the Android device. Is that something that you think that Supreme Court in Canada would take into account, the user rights of the Android users?
I think it would, given our last decision by the court, which was the Access Copyright and York University decision, which was about, from a fair dealing point of view, fair dealing for the purpose of education. In that decision, the court did not decide on that issue itself, rather made an obiter on this point, but it specifically made the obiter to say that when analyzing fair dealing and looking at the fact that it is a user right, it has to take into consideration the perspective of the end user. So one may think that fair dealing for education is an exception that targets educational institutions primarily, especially since we have, beside that, fair dealing for private study, where there you might say that the target of the exception is the end user who is making the study. But our court instead said that even for analyzing fair dealing for education, the analysis should consider the behavior and the purpose of the user that is the ultimate user of the education, which is the student body. So I think that we would have this same attitude in Canada, given this obiter.
And how do you deal with that in the context of the Warhol decision? Who's the user who has a right to use the Warhol revision, repurposing, appropriation of the Goldsmith photograph? Who is the user there that has the right? The museums, the public at large?
I think it would be very interesting to see a Warhol work, like the one he did in this case, being used by someone else in the same manner that he used the Goldsmith photograph. And then I think the difference in attitude would probably come out. So in French, we say l'arroseur arrosé. So it's, I think that I think the right perspective on who is the person who is claiming the exception should be is the exception, whether it is qualified as exception or as a user right, is something which should be analyzed from the perspective of the person who would need to be exercising the right. So the museum, well, we now have in Canada this right of public display for works created since 1992, I believe, or even 87. So this is a right which is part of the a painter's right. Let's say if he does a painting right now, but I think that the difficulty with the analysis that was made by our obiter in our Supreme Court, it's that it tries to use the exception in a context where the right itself is not what is being exercised, it's just use. So I think it makes more sense if we look at an education context to use the education exception when you are an educational institution or a teacher, and it makes more sense to use private study when you are a student. In the case of parody, I think the user would not be a museum, I doubt it. And if somebody from the public wants to make a parody of Warhol serigraphs, well, then let's just wait and see what this parody would look like. But that would be the situation where the parody exception would be used in the States, I would think.
Okay, thank you. So we have one, probably time for one question. We have one question from the audience, which is about how you determine the quantity used, whether I guess the substantiality of the copying, how do you determine what is substantial or not in the fair use and fair dealing context? We saw that, I understand that that Daan said that the amount of substantiality of the proportion of the work that's taken is not a major analysis in the fair use context. I find that surprising from a Canadian point of view, that you wouldn't look at least initially at the amount and substantiality of the amount taken. So the question from the audience is, how do you determine that? And who would like to jump in there on that question.
Well, I'll jump in. That factor is sometimes restated as, did you take more than you needed to take for your transformative purpose? Which again gets you into somewhat turbulent waters, because then it means that the judges deciding how much you needed to take for your purpose, and is that second guessing artists and creators. On the other hand, the factor, if it doesn't require an inquiry of that sort, then it just descends into, I'm an artist, I'll tell you how much I need for my purpose, go away. And I'm not sure that courts should completely genuflect in that respect either. But the statute certainly does direct an inquiry into that consideration, and the Supreme Court remanded on that consideration in the Campbell and Aiko-Froese case. So the Supreme Court has not said that if transformative, end of story, even if some of the later lower court decisions somewhat look like that. Just to give another example from one of Daan's cases, again involving a photograph, where I think the court looked at the amount of substantiality in finding fair use, was the photograph was not used in its entirety. It was used as part of the reproduction of the front page of the New York Post in order to make a comment about the New York Post's coverage of the event. And so some of the photograph showed up in the reproduction, but there it wasn't necessary to show the entire photograph in order to make a point about how the New York Post was covering the story. And the court found that it was fair use because it was enough was taken so that you could see that it was the front page of the New York Post, but they didn't take more than they needed for that purpose. Would you agree with that, Daan?
Yes, absolutely. And I don't want Brian to have the idea that it's completely disregarded. I mean, you still look at the factor. It's just usually a little bit more, it's usually more straight ahead that it would support a finding of fair use if you're just taking a very small amount. And if you take the whole thing, then that sort of usually weighs against a finding of fair use. But there's also this consideration of whether or not you took the heart of the work, the main part of it. That's an issue that's come up in case law as well. It just tends to be that the focus is usually more on the first factor of transformativeness or the fourth factor, effect on the market or potential effect on the market.
Yeah, thank you. We're almost out of time, but we do have one more question, and I think we would like to, if we can just deal with this, it's a person has been waiting for a while. The question is there a risk that if the Warhol's case is found to be fair use, it creates a scenario where the more famous the infringer is, the more likely it is that their use is to be a fair use? In other words, what is the fact that the commercial success of Warhol and Prince and these people, is that a factor in any way that should be considered?
The Second Circuit was very sensitive to that and explicitly said that it declined to create a celebrity plagiarist privilege, because the district court, in its analysis of the market harm, said, who wants a goldsmith? People want a Warhol. The market's for Warhols, it's not for goldsmiths. And I think the district judge was somewhat roundly taken to task on that, where the Second Circuit quite clearly said no celebrity plagiarist privilege. But I think Ysolde had a comment as well.
Yes, what I wanted to say was that in terms of quantity of what is used, obviously it will vary. It's not the same quantity analysis for all fair use or fair dealing purposes. And in particular, when one is looking at parody and satire, there has to be a recognition factor that perhaps allows for more taking than in some other situations. That's all I wanted to add.
Well, thank you very much, Ysolde. Thank you all. I think we're out of time. There's been a chat message here about where you can find the slides, and that's on the chat, the email address where you can get the slides. And as I said, this was recorded, so I believe that AIPPI will make a recording available in due course. Just a little plug for the AIPPI annual meeting in San Francisco, September 10 to 13. It's now back in person now, and it will be an interesting meeting. I can tell you there's a lot of copyright panels at that session. And hopefully if you are interested or remember the AIPPI, you will register. The early price registration ends on June 27. I really appreciate our American friends for coming here virtually to Canada to tell us a bit about the U.S. law, which we always find fascinating and interesting. And as Ysolde said, we have so few cases. We are jealous in a way of how you can find a case on almost anything and have some kind of interesting discussion. We have to kind of scrounge around from first principles mostly. But anyway, having said that, thank you very, very much especially to our American friends, and for Ysolde for stepping in at the last, more or less late in the day. And with that, I'm going to sign off. I don't know, Cynthia, whether anything, and just say goodbye and press leave. And I think that's what I do. So goodbye, good luck. Thank you very much.